Thank you very much, Peter, for that very kind introduction. In fact, I'd like to thank Peter and all of the colleagues here at Munster for their great support, wonderful support since I arrived here with my family in late August. And I have to say that something like a pilgrim going to the Holy Land, I've really enjoyed studying being in the place where the events that I study actually took place. And just as a short example, the Bachrach, which I think is right over there, appears in a charter from Henry III, which I had a chance to read a couple of weeks ago. And so it's very, very nice to be able to see the actual church where Henry III carried out his business of ruling. And I also want to point out, all of you who live in Munster probably already know this, that there's a wonderful Italian restaurant right around the other side, Lazzaretti. If you haven't been there, I strongly recommend it. My talk today is going to be divided into three parts. As Peter mentioned, I'm starting with the question, I came to Munster with the question, were there royal courts in Salian Germany? And so I've divided my paper into three parts. The first part is an effort to give an orientation to those of you who are not necessarily familiar with the larger questions dealing with Carolingian, Etonian, and Salian history from a legal, administrative, and constitutional perspective, give an introduction to those questions, and to let you know where I stand on some of the major issues. The second part of the presentation will be perhaps more interactive. I'm going to go through this text that hopefully all of you have seen and explain how I read the text. And then the third part of the presentation, I'm going to discuss my findings so far, having read through all of the Salian royal charters, as well as a selection of what usually are called, at least in English, private charters, charters issued by bishops and abbots. So to start out with the larger questions of constitutional history, Verfassungsgeschichte, most of my recent work, certainly over the last 5 years and maybe 10 years, has considered the challenges posed first by the older constitutional history and then by the newer constitutional history, and how those two ways of thinking about the way the organization of the German kingdom have challenged, changed, and developed over the last 120 years. For those of you who are unfamiliar with the older constitutional history, this historical movement developed in the course of the 19th century and posited that the political structure of the German-speaking peoples emerged from the free forests of Germany, and then were greatly influenced by their contact with Rome. So that ultimately what developed was a strong state, at least from the point of view of, at least from the 6th century onwards, under the Merovingians, with a king, with the sense of an abstract concept of the state, with offices, and one that continued on into the Carolingian period, the Regnum Francorum, reaching its apogee under Charlemagne. Now, this state, from the perspective of the old constitutional history, was based on the idea that the ruler was not challenged by a nobility, but rather the ruler had a relationship with all of the free people within his kingdom, and there was no inborn aristocracy. There were mighty subjects, but all of them were legally, constitutionally of the same level. Now, this model of the old German constitution was challenged beginning in the period after the First World War by what came to be known as the new constitutional history. In fact, the leading scholars in the new constitutional history called what they did Verfassungsgeschichte, and called what the people in the old constitutional history had done Konstitutionelle Geschichte, because what they said was that the old historians had imposed a 19th century bourgeois model upon the Middle Ages, and that in fact there was nothing like a strong king, nothing like an abstract concept of the state, nothing like offices, that in fact what there was a king who was simply a primus inter pares, and that the aristocracy, and this was a key development of the new constitutional history, that the aristocracy had inborn rights, that they were essentially an autogenous aristocracy, that their rights were of the same kind as the king, and that they shared with him the power in the realm. Now, there were several other elements of the new constitutional history which have had and continue to have in some cases long-lasting impact on the study of German history in the early and high Middle Ages. The first of these was the idea that because the nobility was inborn, there had to be a distinction between the nobility and everybody else. The old constitutional history, and this was, of course, the standard view of French historiography and English historiography as well, was that there was a large mass of free individuals who were directly under the king. The new constitutional history could not have this distinction of free people because there had to be some way to distinguish the nobility with inborn rights from everybody else. So the new constitutional historians invented the category of the king's free, the Königsfreien. And the idea was that those people were only kind of free. They were free because of the service they provided either to the king or to a great magnate. Another element of the new constitutional history was its rejection of the model of an abstract state and a rejection of the model of a state with offices, particularly offices of the type that other scholars had seen playing out in Carolingian capitularies. And a relatively new element of the constitutional history, of the new constitutional history, was the development of the idea of the consensus fidelium, or the idea that the king was unable to carry out any large-scale plans without the agreement and discussion of the great nobility. Now, there was no one set of views among the new constitutional historians about many of these various issues. Some of the scholars in this tradition held, for example, that the Carolingians actually had an abstract state with offices, that the king actually had a relationship with the great mass of free people, and other scholars in this tradition held that, in fact, nothing that we see in the capitularies had anything to do with what happened on German soil, that they drew a distinction at the Rhine. Whatever the capitularies had to say may have had something to do with what developments in the Frankish kingdom, of the Romance parts of the Frankish kingdom, but nothing to do with the German-speaking parts of the Romance kingdom. Now, the new constitutional history was the dominant force in German historiography up through the 1950s, and in some cases up through the 1960s. But the tumultuous events of the 20th century did lead to a rejection of a number of key elements of the new constitutional history. The most important of those was the rejection of the idea of the Königsfreien. That is the idea that there were free people only in the limited sense that they served the king or some other great magnate. This construct of the Königsfreien was demolished, one might say, in the course of the 1960s and early 1970s. It is not accepted by anyone anymore. However, and this is a crucial point and one I'll come back to repeatedly during the rest of my talk, the fact that the Königsfreien were eliminated from the historiographical discussion did not mean that the great mass of free individuals were reintegrated into the study of German history. What has happened instead is that the new constitutional focus on prosopographical history, particularly that is the study of groups of people, particularly prosopographical history of the nobility, has remained the dominant prism through which to examine the German kingdom up through the present day. There are several other and very important, I would say, lacunae that have continued on in German historiography. One of them is an examination of what in English vernacular we would call the nuts and bolts of governance. The question that I always pose is how things are done. So administrative history, for example, in Germany in the 10th century, 11th century, is not received a great deal of attention. And this is startling when one compares the study of administrative history in Germany with the study of administrative history in the contemporary French kingdom or the contemporary English kingdom, or increasingly in the Iberia and in the Italian peninsula. And this is despite the fact that for the study of administrative history, we have far more sources for Germany than we do for France or England, particularly up to the period up to about 1100. So that's sort of a background of where the state of play was in terms of the questions that I got interested in. Now, I started my investigation of German history really from a military perspective. As Peter pointed out, my first book was about military history. Much of my subsequent work was about military history. And a book I wrote about 12 years ago focused on the ways in which military organization in the Ottonian kingdom of the 10th century drew upon Carolingian precedents. And I argued there that Ottonian warfare in the 10th century was essentially Carolingian warfare, just a century removed. Now, about 10 years ago, I started edging away from military history and looking at more administrative matters, governmental matters, and particularly the organization of government at the local level, looking at matters particularly related to the organization of law courts and how the ruler provided for justice for his free subjects. And in a series of articles, many of which were published in the Sabine Stiftung, I made a number of arguments, and I'll lay them out here because they will inform my discussion both of this text that we're all going to look at and also the material that I developed over the last couple of months working in Munster. So the first argument that I've made is that Ottonian kings and queens, and here we can think of Theophano and Adelheid, both ruled and governed their realm in a manner consistent with the model set out by Carolingian capitulators. This is relative to the Ottonian kingdom. And in doing so, they drew upon and shared the abstract concept of the res publica in a way that is best understood in the modern sense as a state. I've argued that counts, viscounts, other royal officials such as the exactores regius, dukes, margraves, abbots, abbesses, and bishops were royal officials. That all of those officials were appointed by the king and served largely at the king's pleasure, or in the case of Theophano and Adelheid, the queen's pleasure. Naturally, and here I do agree with those who have made a strong case for the model of consensus fidelium, that the magnates were involved in discussions about who should be appointed as an abbot or an abbess. But in my view, the king was always the dominant partner in these discussions. I also argue that although the model of the consensus fidelium, the political conversations of the king with his magnates is very important for the understanding of the Ottonian kingdom, this way of looking at the world has very little to do with the way that government actually operated on a day-to-day basis. That is the collection of taxes, the management of royal estates, the raising of the army, the building of fortifications, the funding of churches, the building of roads, and so on. All of those tasks that kings undertake, which have very little to do with conversations with the nobility. I've argued that the autogenous nobility is a historiographical myth. To put it a little bit bluntly, that it was foisted upon the earlier Middle Age period on the basis of a narrow reading of a small number of later medieval documents, primarily from the region of modern Austria, and that the lack of evidence for autogenous lordship in the early Middle Ages was actually acknowledged by the scholars in the new constitutional history, such as Heinrich Mittheis. For example, in his review of the book by Otto Brunner, Land und Herrschaft, Heinrich Mittheis said that we should accept the existence of an immunity from royal judicial authority for all secular nobles in the Frankish realm, wenn auch nicht urkundlich belegbar bestehen der Immunität des weltlichen Adels geben. That is, even if there is no evidence in the 10th century that there was such an immunity from royal authority. His argument was simply that this model works and therefore we should accept it. Now we come to the core of my research about royal courts. There were very large numbers of free people, including both those who owned their own property and those who lived on the lands of the great secular and ecclesiastical landlords, and also of lesser landlords, who were subject directly to the king and were not under the Mund or protection of individuals without offices. This is important because these were the people that the old constitutional history were worried about. These are the people that the old constitutional history said were subject to the king. And these were the people that the new constitutional history said did not exist, that there were no free people in the German kingdom of the 10th century other than the nobility. My argument is there were, and there were lots of them. These individuals, these free men, served in the king's army. They built his fortifications. They worked on his roads, and they built canals, and they built roads, and they did so on the basis of their obligations to the res publica in the abstract sense, not because of a personal relationship with the king. As a concomitant argument, attendance at the comital placitum or malum, that is the comital law court, that is the royal law court at the local level held by the count, was both a right and a responsibility of all free men living with the comitatus of the count, who was appointed by the king. The holding of placita by the counts in the Attonian period, as I argue, was governed by the same rules as it had been in the Carolingian period. And these were set as, and we can see these rules not only in prescriptive form in Carolingian capitularies, but also in descriptive form in charters issued by the Attonian kings, and also in private charters issued by abbots and bishops that have survived in various collections. And one of the very interesting continuities that we can see in these comital placita is the participation by scabini, a new class of judicial officials or judicial experts inaugurated by Charlemagne, who appear in comital cases, not only in the west of France, and the west of the German kingdom in Lotharingia, but also in eastern regions and also in Bavaria. So what this means is that we see continuity of the structure of the comital court and the personnel of the comital court from the Carolingian period into the Attonian period. We also argued, and this is very clear from immunity clauses and from the particular immunity clause we'll discuss today, that ecclesiastical institutions which received immunities from comital intervention for their dependence in legal matters were required by the king to provide the same placita for their free dependents that were otherwise available to free subjects of the king in comital placita. And they had to provide these under the same terms. Now, in many cases, this meant the inclusion of scabini in the judicial decisions of courts held under the aegis of an abbot or a bishop to whom the judicial bonum had been delegated by the king. So in effect, the abbot or bishop simply took the place of the count for a small subset of the free people living within a particular region. The exercise of public authority through the bonum, which included authority in judicial affairs, as well as the mobilization of free men for military service, and this is interesting, also unfree men who were property holders, and as well as the mobilization of all kinds of people for corvée labor, required delegation from the king. This means no one held the bonum without holding an office, and no one held an office without having that office, at least de jure, from the king. Now, politically speaking, we can say that in periods of royal weakness, individuals gain offices that the king might not have wanted them to have. But juridically speaking, all of those offices were within the king's power to grant, and theoretically, and in fact, in some cases, the king withdrew those offices from individuals. I haven't written, but I would hope to write someday an article about this, about Henry II of Germany and his withdrawal of the comital office from individuals. So as a corollary to the question of the bonum of office holders, there is no evidence in the Attonian period for anyone without an office exercising the bonum legitimately. Does this mean that various authorities didn't exercise power illegitimately? Of course not. We see both office holders and important people without offices doing all kinds of bad things all the time. But then again, we see that happening today as well. And there's also no positive evidence that anyone holding a public office exercised the bonum for any reason other than the fact that he or she held a public office. So in sum, the Attonian realm was very much a Carolingian style state. And here I'm stealing the idea of Anglo-Saxon England as a Carolingian style state, in which the king is the chief office holder in the using the concept set up by Louis the Pious within the res publica, had four main responsibilities. These were the defense of the realm, 2, the support of the church, 3, the protection of the poor and weak, and 4, the overarching responsibility for the maintenance of public safety. which included the obligation to provide a forum for the peaceful settlement of legal disputes of his free subjects. So a crucial next question then is, what happened under the Salians with regard to the administrative and legal structure of the realm? Which brings us again to part 2 of my paper, which is this discussion of an immunity and a disputed immunity held by the Bishop of Osnabrück. And it's to that I'd like to turn now. And if anyone doesn't have a copy of this, I'm going to quickly read the English translation of the text, and then I'm going to set out some questions that I've raised about the text and explain how I see this text as relating to the question of whether there were not royal courts under the Salians. But before I do that, let me just say this text was issued by King Henry III. This charter was issued by King Henry III. We have the original surviving, and it was issued in May of 1051 for the Bishop of Osnabrück, and it was preserved in the Episcopal Archive of Osnabrück from that date till, well, now. And if I ever go to the Episcopal Archive in Osnabrück, I will very happily look at it. So here's the English translation of the text. In the name of the Holy and Indivisible Trinity, Henry, by the favor of divine clemency, august Emperor of the Romans, let it be known to all of the men faithful to Christ and to us, both in the future and in the present, which reverses the traditional Carolingian way of saying things. They usually say in the present and the future, that Bishop Albrecht of the Church of Osnabrück approached our imperial clemency to make a complaint about Count Bernard, namely that the Count is constraining the free men in his diocese called Malmen. And for those of you who are not familiar with this particular legal term, Malmen were free dependents of the church who held benefices and were under the protection of the bishop. He constrained them by force and by the unjust use of power to come to his court. When the bishop and the aforementioned Count came to our court with regard to this matter, it was determined, and this is the problem with doing legal history in the 10th and the 11th century, it's not made clear in any way how it was determined, only that it was. It was determined that the aforementioned church shall not be burdened by such great violence henceforth. Therefore, we forbid in every possible way that any duke or count or viscount or any other person holding judicial authority shall presume to constrain, and here's the crucial phrase, his free men, that is the Bishop of Osnabrück's free men, or slaves, just throw him another bone, other than his advocate. Furthermore, so that a conflict of this type shall not arise further between their successors, we prohibit this by our imperial authority and confirm this. And then so on boilerplate. So this is a crucial text. This text tells us a lot of things about what judicial immunities are about and what bishops want and what counts are doing. Because this charter is not a prescriptive text saying bishop shall do this and count shall not do that. What this text is saying is the count was doing this and the bishop was complaining about it. And now the count is not allowed to do this anymore. So what is the count actually doing? What the count is doing is saying that the free men who live on the lands of the bishopric, which are located within his comitatus, have to come to his court. Now the bishop has an immunity, a judicial immunity from the king. I think the Bishop of Osnabrück has an immunity going all the way back to Otto III. So it's about 100 years old at this point, 75, 80 years old at this point, that the free men living on the lands of the bishopric of Osnabrück are not to be summoned to the count's court. Yet the count is doing it. The count is summoning the free men of the bishop to his court. Okay, so the bishop is very upset about this. But why are they upset about this? Why would the count in the first place want to summon the free men of the bishop to his court? And why does the bishop not want him to? Well, like many other things, it comes down to money. Because the more business the count generates in his court, the more money goes into his pocket. And why does the bishop not want his free men to be summoned to his court? Well, there's two reasons. One, again, money, but also power. Because he wants to control his free men. He wants to exercise his protection over his free men. And he doesn't want the count interfering in the affairs of his diocese. So the count is saying that the free men of the bishop have to come to his court. And that means if there's a case at the court, the freitas, the part of the judicial settlement that goes to the holder of the court, goes to the count. and not to the bishop as they would if the freemen of the bishop went to the bishop's court. That's one thing. But two, and this is also very important, Carolingian capitularies make clear that counts abuse the free people living within their comitatus by summoning them to court more often than they should. Carolingian capitularies state that a count should only have 3 procita a year, but they don't make clear why. It is an abuse to summon free men to court more than 3 times a year. One can imagine that one of the problems with that happening is a farmer has to leave his lands. He's got to travel a day or two to go to court, got to spend there a couple of days and come back. And the more times he has to do that, that's a big disruption in his life. That's clearly a problem. But what's also going on, it's hidden in the Carolingian capitularies, but we see it in charters, is the count is demanding fees from people who come to his court. So every time that a free man shows up at the common court, he's got to pay a fee to be part of the court. And so summoning a man 3 to 3 courts is the limit that the Carolingian kings were willing to allow. The same thing is true under the Etonians, and the same thing is true under the Salians, that there's a limit of 3 courts to which a man can be summoned. The count wants the free men of the bishop to come to his court, not only so he can get the fredos, but also so he can get their fees when they show up to court. Now, the bishop has succeeded in getting the king to reaffirm his immunity. But what does this tell us about royal courts? We know the bishop has a court. We know the bishop has a court in which the free men of his living on his lands, or a particular subset of the free men living on his lands, have to go to his court. But what does this tell us about the count's court? Well, first, we know from this charter the count has a court. How do we know that? We know it because he's summoning the free men of the bishop to go there. The second thing we know is that the people who go to the count's court are free men. How do we know that? Because it's the free men of the bishop who are being summoned there. And what else do we know about the court that the count has? The count's court draws from a specific geographical region. How do we know that? Because it's the lands of the bishop within this count comitatus who are being summoned. Not this count, the bishopric of Osnabrück is not coterminous with the comitatus of Bernhard. The bishopric of Osnabrück is divided administratively among a great many comitatus, but it's only the men who live within the comitatus of Bernhard who are being summoned to the count's court. So we know that there's a royal court headed by the count who has jurisdiction of the free men living within his territorially defined comitatus, and the bishop doesn't want his free men, his small men, to be summoned there. Okay, so we know we have 2 different kinds of courts. What we don't know, and what is very frustrating, is whether the procedures in these 2 courts are different. We don't know what law is being practiced in these 2 courts. All we know is who the head of the court is, the communal court and the bishop's court. There's one other court that we could talk about. That one other court is the king's court. Because where was this case settled? This case was settled at the king's court. So that's a third court. It's not the kind of, it's a royal court, obviously, because it's headed by the king, but it's not the kind of court that I'm going to spend any more time talking about. But it's worth thinking about that there is a third court mentioned in this text. Now, there are a couple other limitations that it's worth noting here. The bishop is only complaining about the male men who are being summoned to the count's court. What about the other free men who are living on the lands of the bishop? Are they subject to the count's jurisdiction? We don't know, because this charter doesn't say so. But the fact that they are not explicitly taken from the count's jurisdiction suggests that other free men living on the bishop's lands are subject to the count's jurisdiction. Now, if this were the only charter we had, we might say this is a question we can't answer. But we have lots of other charters which deal with immunity questions. And these other charters illuminate communal practice. We have a very enlightening charter, for example, issued by King Henry II on behalf of Bishop Bachrach of Worms, I believe from 1021. I don't have the text in front of me. And this text makes very clear that Bishop Bachrach of Worms is worried about exactly the same things that the Bishop of Osnabrück is worried about, that the count is compelling his free men, that is the free men living on his lands, the free men who are part of his familia, to go to the communal court. What Henry II decided was, insofar as the cases involved only the free dependents of the bishop, that those men should go to the count's court in a case heard by the advocate. But, and this is a very important but, if the men of the bishop were engaged in any sort of litigation, what we might call civil litigation or a criminal litigation against someone who was not part of the bishop's familia, they had to go to the count's court. And not only that, the count had the right to go within the septa, that is the immune district of the bishop, to go get those men if they didn't come willingly to his court. So based on that model, it's likely that if any of the Bishop of Osnabrück's free men, any of the free men living on his lands, engaged in a conflict with a free man outside the bishop's familia, they too likely were subject to the count's court. So this is just one charter. We have about 800 charters from the German kingdom under the Salians, which are legitimate and are for Germany, not for Burgundy or not for the land south of the Alps. Of those 800 charters, about a third deal with the judicial immunities in one way or another. Bishops and abbots are constantly trying to get the king to affirm, reaffirm, grant judicial immunities to them from communal oversight over their free dependents, and in many cases, their unfree dependents as well. Now, the fact that they're trying to get the king to affirm their judicial immunities over their unfree dependents lets us imagine that unfree dependents also might be subject to communal authority in some circumstances. We can imagine, for example, an unfree dependent of the bishop attacking or stealing from a free man who is not the bishop's dependent, and that being subject to the count's justice. So about 250 Salian charters deal with immunities in one way or another, and the efforts of abbots and bishops to keep the counts out. The constant refrain, the constant effort of bishops and abbots and abbesses to keep the count out of their business, to keep the free men, and in some cases unfree men, living on their lands, their dependents, members of their familia, or just their tenants, from having to be subject to the communal court, allows us to see, probably, that the Salians had the same system of communal courts at the local level that we can see under the Etonians and that we can certainly see under the Carolingians. Which brings me to the third part of my presentation, which is what I think I've learned so far. Now, this is always subject to change. But as my discussion of the text issued to the Bishop of Osnabrück indicates, the Salian kings, I think, adopted the institutional structures from their Etonian predecessors with respect to the role of counts in holding royal courts for the king's free subjects at the local level. As I mentioned, we have hundreds and hundreds of royal charters, of which 250 or so deal with immunities, and the counts appear in these charters as the main representative of royal authority at the local level. Now, one of the idiosyncrasies of Salian charters, as contrasted with Etonian charters, is the appearance in much greater numbers of viscounts, that is, vice comites. Etonian charters mention vice comites once in a while. Carolingian capitularies are full of them. Carolingian capitularies make clear that their counts had subordinate officials who ran local courts which had less competency than the communal court. Not the three main placita held every year, but local courts which dealt with Lucar's pig who came onto Bodo's land and caused a little bit of damage. We can have that handled at the court of the Viscount. So under the Salians, we see these viscounts appear much more frequently. As a result of seeing these counts and viscounts operating in immunities, and I've just begun to look at private charters, they appear there as well. What that suggests is that counts were responsible for organizing and supervising placita in which the king's subjects could peacefully address their legal grievances. And from an administrative perspective, it's also important to emphasize that the administrative political structure of royal justice at the local level was very similar. In fact, I would say the same under the Salians as it was under the Etonians and Carolingians up to this period in the 1070s, which we see a fundamental breakdown in Salian authority. And so the first part of this was the pagos. Now, the pagos, the German version is Gau. It was under the Carolingians and under the Etonians, and it looks to me also under the Salians, at least up through the late 11th century, was a permanently defined geographical area with specific boundaries. Why do I say that? Pagus boundaries are given in some rare circumstances. For example, we have an interesting case from Henry II, where the king holds an inquest to determine the specific boundaries between two pagi, because there's a conflict between two counts over legal jurisdiction. So the boundary between their pagi has to be differentiated. We also have some very interesting papal confirmations of the diocesan boundaries of German bishoprics in the later 11th century, for example, Halberstadt, and the boundaries used to define the episcopal diocesan boundaries of the diocese are the pagos. A list of pagi is given, and those are the boundaries that are used to define the episcopal boundaries. They have to be fixed in order for that to be true. So over time, of course, pagus boundaries do change. Certainly a pagus from the Merovingian period is not going to be the same pagus in the Carolingian period or the Salian period. Now, the reason for that has to do with demographic change. The population of what is the German kingdom in the 10th and 11th century is much larger than it was in the 6th century or the 7th century. It's probably 3 or 4 times larger than it was. This is seen in lots of different ways, one of which is the massive deforestation of Germany and the creation of huge quantities of farmland. So as populations increase, pagus boundaries change. Sometimes they get bigger. Sometimes forests that were part of pagus get added in as they get settled. In other cases, pagi become so densely populated that they're divided. And that a pagus, which used to have 1 count and several viscounts, now is divided into 2 or even 3 pagi. Now, the comitatus is something different. And this is something we could probably spend the next 27 years arguing about. But this is my model of what the comitatus is. I stand on one side of a big historiographical debate about this. The comitatus was a political and an administrative unit. The geographic, it was one meaning of comitatus was the geographical area over which the count exercised his bonum. That is the area within he had judicial authority and military authority. The comitatus in the Carolingian period often included just 1 pagus, but under the Etonians, counts often had multiple pagi within the same comitatus. Depending on the size and population of a pagus, the count might have 1 or more vice comites. And in some cases, we can see, as I mentioned before, that in particularly densely populated pagi that become divided, before that happens, the same pagus might be part of 2 separate comitatus. That is, 2 different counts might have legal and judicial authority within separate parts of the different pagus. Now, from a historiographical and source perspective, there's a big complication in the term comitatus, and this has led, in my view, to a considerable misunderstanding among historians. The first meaning of comitatus is the geographical area within which the count exercises his bonum. But comitatus is also used by both the Etonian royal chancery and the Salian royal chancery to mean the fiscal goods which were used to maintain the count in his office. So a count has a comitatus, which is a geographical bonum, and the count has a comitatus, which is a reserve of fiscal assets. And earlier generations of scholars often argued that the comitatus, which was a bundle of fiscal assets, was actually an area of jurisdiction or the lands governed by a count. That's not true. And I'm hoping next year sometime for Peter to see an article from me about this very question in Salian Stiftung. So when you see that a king has given the comitatus of a certain count to a particular bishop, that comitatus might be the office, the bonum, the jurisdiction of that count, and it might be the fiscal assets attached to a communal office, or it might be both. And the only way to know is to see discussions of that particular region later on and what the bishop or count do. Now, as I mentioned, up through the 1070s, the Salians maintained the Etonian system and its various administrative and legal elements. However, the civil wars of the 1070s and 80s, the renewal of conflict in the 1090s, up through the end of Henry IV's reign in 1106, led to a major deterioration in royal authority and power. This deterioration continued during the reign of Henry V, particularly in northern Germany. This erosion of royal power had a significant impact on the administration of royal justice at the local level, which required both respect for royal authority and fear of royal power. That is, individuals who don't fear the king and don't respect the king have no desire to follow the king's rules. Now, there are two connected factors that play a significant role in the changes in the nature of justice at the local level under the later Salians and thereafter. On the one hand, we see a major transformation in the nature of the office of the advocate. This office, which dated back to the Frankish kingdom of the Carolingians and probably even to the Merovingians, was established by the king initially with the ostensible purpose of helping ecclesiastical officials represent their interests in court cases. The office also served the typically Frankish function of providing a check on the authority of ecclesiastical officials by dividing power and responsibility among several individuals, what I like to call creative tension. The Etonians retained the office of advocate in the same manner, but under the Salians, we begin to see a changing balance in the authority of the advocate and the ecclesiastical magnates whom they ostensibly served. The advocates increasingly came to dominate the affairs of churches with regard to their material assets, not only in terms of representing their legal interests in court cases, but also in the allocation of these assets. Advocates started dipping their hands, as we would say in English, into the honey jar and taking things for themselves. Up through 1056, advocates worked in the royal interest as well as their own because they feared Henry III. However, during the minority of Henry IV, from 1056 to 1066, and the civil wars of the 1070s and onward, the consequent erosion of royal power and authority meant that the balance now shifted towards the interests of the advocates themselves. So how did this change in the behavior of advocates impact the organization of courts at the local level? To address this question, it is necessary to consider another tendency in royal governance that began in earnest under the last Etonian king, Henry II. This ruler expanded upon the earlier Carolingian and Etonian practice of granting immunities from communal authority by granting communal authority to some bishops over entire pagi. This meant that abbots and bishops no longer had the bonum over their own unfree and free dependents, but also over the free people living in the entire pagus, where they now took the place of the count. This meant that in some places, bishops exercised the bonum in legal affairs and also in some cases in military affairs over large numbers of free people. Under the Salians, this practice accelerated in some regions of the German kingdom. And again, why I'm very glad to be here. This is particularly true within the borders of the modern state of North Rhine-Westphalia. In some places, the king specified that the bishop was to appoint a comes to fulfill the obligations previously held by a comes appointed by the ruler. That is, now the bishop got to pick the count instead of the king. However, in many other places, in most places, in fact, the judicial aspects of the bonum were not taken over by a count, but rather were taken over by the advocate of the church. As a consequence, as advocates began to pursue their own interests, even in opposition to those of the Salian kings during the course of the 1070s and later, they also began to use the bonum in judicial affairs to pursue their own interests as well, against the rights of free people living within those pagi. The greater the immunity held by an ecclesiastical institution, the more scope the advocates had to abuse their authority through the auspices of the placita, which they now controlled. The later Salians did not simply accept this situation. Henry IV, for all of his flaws, was a fighter. And so instead of just giving in, both Henry IV and Henry V tried very hard to limit the scope of the authority of the advocates. They tried to limit the rights of the advocates. They emphasized the right of the king to remove advocates and to appoint them. They tried to reinforce the rights of the actual immunity holders, that is the bishops and the abbots, and also to emphasize the rights of the king's subjects in judicial affairs. Unfortunately, for the free people of Germany, It didn't work. Henry IV and Henry V failed. And you can see how this plays out in the subsequent history of Germany, where the free people are actually crushed under the heel of a large dominant noble class. So we see this process playing out very clearly in the charters of the later Salians. And so I'd like to conclude with a brief discussion of one of these charters issued by Henry IV in conjunction with Bishop Baldric of Liège at the Royal Court of Aachen, Royal Court held in Aachen in June of 1101. As the document makes clear, it's a very long document, I didn't translate the whole thing, but as the document makes clear, the Royal Court heard complaints by Abbot Stephen of the Monastery of St. James at Liège that Count Arnulf of Los, the advocate of the monastery, had abused his authority, particularly in legal matters, which led to the oppression not only of the tenants of the monastery, but also of the brothers and the abbot himself. The first charge was that Count Arnulf, who had been appointed as advocate by the king, had granted this office as a benefice. One never sees this under the atonements. You never see the office of advocate being granted as a sub-benefice to a man named William of Namur, with the result that the abbot and king both had lost the ability to hold the advocate to behave within the boundaries of his designated office. The second charge was that William, acting as the advocate, had imposed unjust exactions on the tenants of the monastery's estates in order, among other things, to provide income to his military household of not fewer than 30 militants. Of crucial importance to our discussion regarding the structure of courts at the local level is the next clause of the complaint made by the abbot, in which he described the different experiences of men living on different estates held by the monastery. On the one hand, Abbot Stephen observed that William was not able to exercise his tyranny at the estate called Ernau, because only the comex was able to hold a placitum there. Quia placitum non nisi de comitato habebat, minus saevere poterat. This means that this particular estate was not covered by the judicial immunity from the common labanum held by the monastery of St. James. And so the count and not the advocate held the court there. On the other hand, at the estate of Silva, where the monastery did have a judicial immunity from the common labanum, the tyrant, tyrans, William was able to impose his evil exactions because he had the authority to summon the tenants to 3 placita each year, where he imposed unjust and amoral exactions. Now, this charter clearly shows the bifurcation of justice at the local level as this was playing out in real time. The survival of the older Carolingian system of royal justice, provided through the auspices of the count appointed by the king and under the king's control, is presented in this charter as protecting the interests of the king's free subjects. When the king is in charge, there is no tyranny. By contrast, the placitum headed by an advocate or a man holding this authority as a benefice from the advocate within the context of an ecclesiastical judicial immunity from common authority has become the forum for the imposition of tyranny. Obviously, this charter was issued by a royal court under the auspices of a judicial decision against William of Namur and Count Arnulf. One would therefore expect to find that the text highlights the good old days of royal control of justice at the local level. Nevertheless, it is also clear that the ideology of the king's responsibility towards his free subjects, and particularly his responsibility to provide a fair forum for the settling of legal disputes, remained potent, even as the king's ability to provide such a forum was disappearing. Thank you.